Welcome everyone, and thank you for joining us for today's webinar, Virtual Lawyering, Growing a Global Practice, presented by Priya Prakash Royal. My name is Stephanie Phelan. I am a marketing manager at MyCase, and I will be your host today. This is a webinar that earns 1 general credit in law practice management in New York, New Jersey, Illinois, Arizona, Texas, Wyoming, and Louisiana. Verification codes will be chatted to the audience in your GoToWebinar chat box during the presentation. So please note those codes if you're in one of those states and you are applying for CLE. There will also be a required survey at the end. For those of you not earning CLE today, it's still worth taking the survey as you will have a chance to win a $50 Amazon gift card. I'd like to first give you a few tips about participating on GoToWebinar. The webinar control panel is on the right-hand side of your screen. This is where you can control audio, chat with me, and submit questions. Please use the questions pane to submit your questions at any time during the webinar. I'll be collecting these questions throughout the webinar and saving them to ask Priya at the end of her presentation, but please don't wait until the very end to shoot those over to me. Below the questions pane, you'll see a chat window. That's where the CLE verification codes will appear. There are also 2 handouts available for download on the GoToWebinar control panel. Also, please note that these slides and recording will be available by end of day tomorrow on the MyCase blog, and it will also be emailed to all registrants. Lastly, the Twitter hashtag to follow the conversation is #GoingGlobal if you'd like to tweet during the presentation. Today's webinar is hosted by MyCase, so before we jump into things, I'd like to give a quick overview. MyCase is a web-based law practice management software that takes care of your daily practice requirements for calendaring, contact management, document management and templates, time and billing, client communications, custom workflows, and more in one solution at a really affordable price. MyCase is priced for solo and small firms at just $39 a month per attorney and $29 a month per paralegal or support staff. We also offer MyCase websites for our customers. The cost to set up and build your website is only $500, and then there's a $50 per month maintenance fee. We use a modern professional design built for your firm. The websites contain social media and blog integration, and best of all, the client portal, which is completely integrated with your MyCase software. So now you and your clients can log into MyCase directly from your own custom-built site. Now for a new feature. Approved MyCase customers can accept payments directly from client checking accounts. This is also known as eCheck or ACH payments, for free with no third-party integration required. By linking MyCase's legal billing tools to your operating trust accounts, you can seamlessly accept online payments into your MyCase account. Best of all, the eCheck payment feature was created with the unique needs of lawyers in mind. Unlike other general business payment processing solutions, it's designed to protect your trust account so you can rest easy knowing that it complies with trust account regulations. Last but not least, we enjoy hosting educational events for professionals in the legal industry, and that's why we're all here today. So let me tell you a little bit about our presenter. Priya Prakash Royal founded the Royal Law Firm as a tax and business law firm after extensive experience with larger law firms representing high net worth individuals and multinational corporations. She continued the firm as a commercial and corporate law firm while employed as an attorney with the Estate and Gift Division of the IRS. Since leaving the IRS, Priya reestablished the firm as a tax, trust and estates, and business law firm. Priya is a solo practitioner with a global client base, admitted to practice in the District of Columbia, Maryland, New Jersey, New York, and Pennsylvania. She's conversant in Hindi, Tamil, Spanish, and French. But most importantly, Priya is an animal lover with 2 rescue dogs at home. She is actively involved with various charitable organizations, including the Animal Legal Defense Fund, working to prevent cruelty to animals. Priya, I'm so impressed by your achievements, and we are so pleased to have you presenting for us today. I'm going to let you kick it off from here. Thank you.
Thank you, Stephanie. Good morning and good afternoon, everyone on both coasts. So I am presenting on the issues and the very idea of running a multi-jurisdictional practice in law. And this is primarily based on my own experience. There are some references to primarily our ethical issues, because as attorneys, generally we are risk averse. So the ethics are usually a bar to, at least for me initially, I was very hesitant to engage with multi-jurisdictional practice just because of the conflicting ethical rules and potentially being cited for the unauthorized practice of law. But over time and circumstances, I have learned to find common ground between the various rules and comply with everything and actually successfully manage a practice across the jurisdictions. And I will admit that with the recent advent of technology and the security features that specifically cater to lawyers, MyCase being one of those examples, it's much, much easier to run a multi-jurisdictional practice, especially as a solo attorney, than it was back in 2009 when I started this practice and went out on my own. So the idea here is that originally most solo and small firm attorneys would tend to focus on one or two areas of law that they were comfortable with, that they had experience in, and maybe one, possibly two jurisdictions that they had familiarity practicing in, were currently residing in, or were near. And one of the problems with that model was that globalization was taking the lead in the world. Businesses are expanding, but we were limiting ourselves to asking the client questions like, is your issue a New Jersey issue or a Virginia issue, instead of being able to answer a client who says, I'm looking to expand, I want to grow my business, I want to sell goods or services all over the world, what can you do and how can you make this happen? So the entire foundation of my firm is to cater to these business and the high net worth clients, because invariably they have business and corporate interests all over the world, and they engage in foreign transactions. And it's to answer their questions where they essentially don't necessarily care about the legal ramifications, but we do, because if in the small chance that they have a problem, we need to make sure that we have protected them. But also being able to tell them that it doesn't matter that you're trying to expand, you can rely on me, my firm, or my team, even if you're a solo practitioner, and provide expansive services while still not losing the focus from your areas of focus or the practice areas and the jurisdictions that you have familiarity, experience, and are, simply put, authorized to practice in. Which, of course, brings to mind the issues such as the unauthorized practice of law. As an example here, I've cited Rule 49A. It's very lengthy. It's several pages long, and the DC bar goes ad infinitum about the various issues that come with practicing in one jurisdiction, giving opinion about the law in another jurisdiction, and the various issues that come with that. One of the clarifications I received from the ethics board recently was that if you prepare documents for a client where the governing jurisdiction of the document is another state, and you happen to tell the client that I think or I believe under the laws of the state this particular provision would not be valid or would be treated in this way, or for example in a trust situation that a particular state is more amenable to decanting or terminating a trust, an irrevocable trust, than not, that would not constitute the unauthorized practice of law in that jurisdiction, which was a breath of relief to get that clarification, because a lot of times, especially in corporate practice, we incorporate the client's businesses in jurisdictions outside of those that we would be necessarily admitted to practice in, just because of the slightly more favorable treatment in terms of the law, the case law, and the history, Delaware being one of the most commonly used examples. So in developing a multi-jurisdictional practice, it's slightly onerous and boring, but one of the first things that you have to look into is to get together all of the ethical issues that basically address the issue of the unauthorized practice of law in every jurisdiction and read them, memorize them, read every commentary on them, and try to find the common ground. So, because from creating the website to attracting clients, to advertising, to actually representing the client, to the type of legal work you do is all going to be governed by that one rule that could create all of the problems with the issue that the multi-jurisdictional practice goes beyond the jurisdictions that you're actually allowed to practice in. And so, one of the big hurdles that I faced when I started practice was I went to law school in Pennsylvania, was originally from New Jersey, worked for a law firm that was representing clients in New York and New Jersey, and ended up taking multiple bar exams consecutively, not by choice, obviously, and then had to move to the DC area for the federal job, and was waived into the DC bar, took the Maryland bar because I knew I had to settle down in the area and I wanted to return to private practice. So as a consequence of the circumstances, I had 5 jurisdictions, and having put in several hours of sitting through bar exams, I just didn't want to give up any of them, so I decided that I needed to make them all work, and that's how the multi-jurisdictional practice came into play. But conveniently, since 2009, most of the states have recognized that arcane rules such as requiring a brick and mortar office in the jurisdiction is no longer applicable in a global world where a lot of attorneys do prefer virtual offices, don't need face-to-face meetings with clients. Most communication is done on the web, by email, phone conferencing. So one of the most recent states to actually remove the brick and mortar rule was Virginia, where they now allow attorneys to waive into the state of Virginia without requiring a full-time office within the state. And New York has expanded its definition of a principal office to include a virtual office, which I'll go into a little bit more later. And the most important aspect after we determine our ethical barriers and what would constitute unauthorized practice of law, and making sure we limit our practice to certain areas that we are comfortable with and in the jurisdictions we practice in, is to take a step back from what the client demands. Usually my clients are internationally based and they want to expand their business into the US. They're looking at expanding and selling services all over the country. For any corporate attorneys among us, the first thing we look at is we have to register this company within the US, either as a domestic corporation and then get foreign authorization, or create a foreign corporation in every other state that they might actually be serving or selling goods. So, and then the client starts talking about franchising, and now we have more issues and we have new practice areas. So instead of that, as a solo practitioner, I listen to the client, I get their big picture, I find out what their end goals are, and essentially create a timeline of events and look at what their future is. And it's essentially almost, I'm developing their business plan in order to determine the type of legal services, what resources I would need, and whether my practice can actually afford to represent this client completely. And if you take it one step at a time, the first thing you have to do is incorporate the client in the US. And that's clearly within our jurisdictional limitations, so that's not a problem. And as we move forward, we start looking at various tools and resources we can use, both technologically and in terms of using the experience and the knowledge of our own peers, collaborations, and networking to be able to provide the client with services that would be akin to a large firm with multiple practice groups, areas, and attorneys all over the world, but without the fee structure and the salaried employees, because we would be charging the client on an hourly basis. With our lower overhead, the rates are not as high as a large firm would need to keep in order to maintain its structure. So with that, we move into the idea of how do you set up your multi-jurisdictional practice? Do you advertise, or do you tell the client that you're admitted in multiple jurisdictions so you can represent them in multiple jurisdictions? Most clients I have initially discussed legal issues with do not care and are not concerned with which jurisdictions we are admitted to practice in and what we can do in under particular state laws. So it is much more beneficial to focus on practice areas as any traditional attorney would. The jurisdictions comes into play as an add-on feature. So if you're comfortable practicing in certain areas, in my case it is mostly tax law, which fortunately implicates almost every other area of the law. So essentially I will find tax issues in any type of legal area that a client has a need for an attorney. And by advertising, holding yourself out as an attorney who's a tax attorney, a commercial litigation attorney, a corporate attorney, things of that nature, you will continue to attract the clients you always have, but including a presence in multiple jurisdictions will expand that client base to include clients who are larger in terms of their size, in terms of their net worth, who are looking to expand operations, global clients, international clients, and these lend themselves to significantly greater amount of legal services, and obviously at the end of the day, increase our bottom line and enable us to provide more interesting and creative services to the client base. The biggest issue with that is the professional liability insurance. On multiple locations, especially for insurance companies that cater to solo and small firm practitioners, they're not familiar and are uncomfortable covering attorneys who hold themselves out as practicing in multiple jurisdictions. Even if you say that you're focusing only in a particular area of the law, as has been the case with my general practice, I offer a lot of tax consulting services to other law firms and other attorneys who are small and solo practitioners, especially without a strong tax practice, because on tax issues in their transactions, they can provide much more comprehensive services to their clients if they have a tax attorney who's consulting them on the tax implications. That creates a problem for the professional liability insurance companies because they want to ensure that you have separated your specific role and made it very clear with the client so that there's a lawsuit in the future, let's say in a real estate transaction, your license and your insurance is not implicated because you provided tax issues with a particular transaction that went sour, even though the tax advising wasn't the cause or the problem with that entire transaction. This requires that our engagement letters be extremely specific, lengthy. The relationships between other attorneys or the specific scope of our services are much more significantly detailed, and the allocation of funds held in escrow, retainers are specifically consented to by the client as being allowed to be held in one jurisdiction over the other, or under some reciprocity agreement. For example, with the client's consent, I can hold funds for a client who retains me under New Jersey law in New Jersey in a DC trust account, but I need the informed consent of the client. So these are some of the issues that the initial setup of the firm, the standard retainer agreements, the standard engagement agreements, the brochures, the information you provide about the firm has to cover, and it has to be extremely detailed and very clear from the onset. Needless to say, from the way I've been discussing this, a transactional practice as multi-jurisdictional for a solo or a small firm is significantly easier than a litigation practice. The litigation practice has much more deadlines, statutes, and it relies heavily on creating paper trails and hard copies. Most courts still do not accept filings. E-filing is not as popular yet in most of the court systems. So a litigation practice requires much more planning and a project management view to it than a transactional practice. It would require retaining staff. It would require having multiple physical locations with the resources that you need, but not to the extent that you would as it was traditionally with multiple offices in various jurisdictions. The best resource that I have found is, one of the best ones is to be a member of the ABA Solo and Small Firm Practice section, and I usually sign up for legal updates from all the bar associations. So that way I have the recent case law and rulings on any updates on ethical issues, the definition of virtual offices, the changes to the definition of what contact with the client would be, what would constitute solicitation, things of that nature, because they are all in a state of flux. The legal profession is catching up to the rest of the world in incorporating social media into the practice of law, but hasn't quite been able to find the comfortable spot where social media and maintaining confidentiality and abiding by the ethical rules would work together. So there are conflicting opinions out there between the jurisdictions, and that can create a significant issue depending on the type of multi-jurisdictional practice one tends to engage in. My recommendation would be that if one has a transactional practice, to not delve heavily into litigation or vice versa, because the basic resources and the structure necessary for each of those are significantly different, and the type of practice that they lend themselves to may result in violations of ethical rules that may not be worth it to just get clients and serve every need from transactional through litigation, unless you have the network and resources and you're comfortable essentially handing off a significant portion of the other type of practice to another attorney, even if they remain under your letterhead as an independent contractor, which also I'll discuss a little bit later. So that brings us to our first poll, which is about multi-jurisdictional practice. This is just to check what the audience consists of. Do you practice in multiple jurisdictions? Please select one of these answers.
Okay, great. Thanks, Priya. And it looks like the majority have voted. So please go ahead and finish up your votes, and I'll close the polls now. Okay, and share our results. Okay, so 24% are it said yes in 3 or fewer jurisdictions. 16% said yes in 3 or more jurisdictions, and 46% said they practice in 1 jurisdiction only. 5% licensed to practice in the U.S. and abroad, and 9% said none of the above to that. So it looks like our majority is in 1 jurisdiction only, which is probably why they're listening to you today. Priya?
Well, that's actually a good thing, because this is essentially a broad-based overview of some of the issues, hurdles, but also the benefits, and essentially makes the practice of law more interesting when you practice in multiple jurisdictions. So this will give you an idea of the type of practice one can engage in if you do decide to expand, and hopefully this can give you some directions of research and information that you'll need to gather before you engage into that venue and pay any more bar dues by waiving into another jurisdiction, or worse yet, sit for another bar exam. So, moving on, we come to the idea that multi-jurisdictional practice is primarily made possible because of the advent of virtual offices. And virtual offices, they don't necessarily have to be the primary office. A lot of people have brick and mortar offices, the primary office and the location where they reside, and the ability to have virtual offices from anywhere from $50 to a couple $100 a month anywhere in the world enables people, even those who are admitted abroad, to have offices and a complete structure, a place to receive mail, a place to be served legal notices and subpoenas, and meet clients without being taken or being considered to be inaccessible to a client. So this creates opportunities, because there are many areas of the law that are although technically and under the ethics rules we can't use the term specialized or specialization, they're essentially specialized. A person with 20 years of experience in a particular area of law is much more well-versed in the developments and able to handle the nuances of that area than somebody who's just come into that area of the law once or twice in their career of spanning less than 5 years. And those attorneys may be the more skilled ones in that particular nuanced area of the law are in one jurisdiction, and they would be having a better client base in another jurisdiction because of some friendly change in the law. For example, practicing corporate law in Delaware would probably be more beneficial than practicing corporate law in a state that is not as friendly to businesses. So this enables the attorney to practice in both areas and serve clients in both areas without physically being in the more favorable jurisdiction. And one of the best ways to create that is you have to find the common ground or the beneficial area where the ability to be personal with your client, have face-to-face meetings, and develop a level of trust because they can see you, they can read your nonverbals, is not compromised or sacrificed in the name of technology and having virtual offices. And tools like video conferencing, and the webinar that you're on currently is actually one of them. GoToMeeting does offer a webcam option. Enables the client to feel as if they're sitting in your office, but they can do it at their own time, in their own convenient space, and they can access all of the documents and information that you would need without having to have multiple meetings, which saves them time and essentially gives you an edge on firms that still offer a traditional model where they want to meet with the client. The way I operate is I always offer an in-person meeting to the client, but it is at their option. I actually use MyCase even for prospective clients, but I very specifically state it's for prospective clients so that they can upload confidential information that I may need to assess a case before they decide to retain me. And then I also incorporate virtual digital signing software to sign engagement letters with retainers, accept electronic payments, accept payment plans for large transactional cases, and I use tools and I confirm that my payment system processing company actually allocates all of the funds to the trust account that used for the credit card payment out of my business checking account, which actually complies with the trust accounting rules of most, if not all, jurisdictions. So at each step of the way, in addition to the business considerations, we run into the ethics and professional liability issues. And it's very easy to make sure that we comply with those rules as long as we don't take that as too high a risk to bear and not move forward with representing a client in a much more broad-based fashion. And the opinion here, the New York formal opinion, was essentially put in as an example of the changing realm of the legal practice, where the bar associations are finally understanding that the nature of our practice has to change. And in 2014, New York did allow for virtual offices to be used as a physical location for a New York attorney or a New York barred attorney. And they specifically stated that because a virtual office does allow legal papers to be served upon the client, and it does provide the client with the physical proximity because they can meet with an attorney in that virtual office. So it met with the requirements of having the physical office. So instead of creating new rules under the changing landscape, the bar associations are essentially bringing the traditional vocabulary and the vernacular of physical office or brick and mortar and adapting these virtual technological solutions into that definition, essentially using the older opinions as precedent. But it is good to see the changing landscape and that they're taking a more expansive view, which should help us risk-averse attorneys to be a little bit more comfortable expanding our practice and services. The next slide is, again, this goes back into expanding and expanded niche practice. The most important thing, as I said initially, after you get past all the ethical issues with having a multi-jurisdictional practice, is to determine the areas of practice that you want to focus on. A general practitioner having a multi-jurisdictional practice would probably have a significantly harder time than a practitioner who focuses on maybe one or two areas and then practices multiple jurisdictions, because at least for me, I cannot keep abreast on every legal change in every area of the law and keep up with the jurisdictional changes as easily as if I just focus on, let's say, tax law and business law changes in 5 jurisdictions. So that's an individual consideration of what you would determine to be your best areas of practice. A lot of times they may be closely related, that you can do multiple areas, but clients are more prone to be looking for what they deem specialists or experts, even though we don't label ourselves as such. And the areas that we're most experienced in lend themselves best to being the areas of focus. And sometimes they expand into other areas. The ABA Model Rules 7.1, 7.2, 7.4 are the rules that elaborate on this idea of our inability to hold ourselves out as expertise. And in advertising specific areas as a niche practice, but that does not stop us from stating that we focus in certain areas of the law, or specifying that we are experienced in particular matters in those areas instead of using terms such as we're generally experienced in those areas. The best part about having a niche practice and then expanding it is, so I'm a tax attorney, but when a client comes to me with a tax issue, and let's say they have a commercial real estate transaction or they are going through a divorce, there are tax issues in separation agreements. There are tax issues with creating the shelter company that's going to enter into the real estate commercial transaction. So I essentially would tell the client that I will continue to advise you on this. I can be your attorney through all of your transactions, and I have a attorney who's experienced in these other areas, who's part of my network, and I can bring that individual in as local counsel or co-counsel, and with the full disclosure in an engagement letter or an amended engagement letter, I can either enter into a fee splitting agreement, or the one that I prefer, because clients find it easier to write one check or make one payment to one firm and sign as few letters as possible, is to have separate independent contractor agreements with these attorneys on a case-by-case basis on that particular transaction, limiting the scope of their representation, and they would be paid as dictated in the independent contractor agreement. At that point, it's very important to consult with the rules, both by the IRS and our ethics board, to make sure that we do not create an employee situation where it's an independent contractor. And I have to make sure that I do not provide benefits to these attorneys. I usually ensure that the attorneys have their own independent insurance. So that way, even if my insurance is implicated, which does cover the independent contractors who represent clients under my letterhead, their insurance would also be implicated on issues that address their representation or their part of the representation. And this is further elaborated in terms of the ethics in the ABA Formal Opinion 330 and the 1990 opinion. The billing and invoicing issues and engagement letter and compensation agreements has been a work in progress. It has taken me several years, and I constantly modify it because the rules keep changing. So it is very important to stay abreast on the law when it comes to fee splitting, because that is a red herring for the Bar Ethics Board when there is a mismanagement of client funds or an issue with how fees are allocated. And based on that topic, we come to poll slide number 2 on the niche practice. This is again to sort of get the temperature of the audience here. Do you have a niche practice? And you can answer, yes, I practice in one area exclusively. Yes, I focus on 3 or fewer practice areas. Or yes, I focus on more than 3 but closely related practice areas. or no, I have a general practice, which means the areas don't have to be necessarily related, or that none of the above apply to me.
Okay, great. Thank you, Priya. And it looks like everyone dove in and is already almost completed with voting. So if you can please go ahead and wrap up your voting, I'll close the poll. And our results. 18% said yes, I practice in one area of law exclusively. Our majority, 44%, said yes, I focus on 3 or fewer practice areas. 28% focus on more than 3 but in related practice areas. And then 7% said they have a general practice. 4% said none of the above apply to them. Is that about what you were expecting to see, Priya?
That's almost exactly what I was expecting, because if you have certain areas of focus, you're perfectly suited for the multi-jurisdictional practice. Otherwise, I think we'd spend more time doing research than actually practicing. So, so that looks like this basic overview of running a multi-jurisdictional practice would be very relevant to most of the audience here, which is always good to see. I just wanted to go a little bit into the touch on some management issues when it comes to managing an expanded niche practice, because it does implicate multiple areas of the law, multiple issues, multiple jurisdictions. It's a multiple in everything with too many variables. And one of the indispensable resources I've found is actually to have the benefit of having an in-house project management expert. And what he does for me is I take every case as a project. So you take a client matter, they come in with a big goal of, let's say, expanding their operations around the world. He will break it down into components so that I can determine at each step, from the point of creating the initial domestic corporation or advising them on how to handle the foreign tax issues, all the way to expanding or getting into the franchising. Who are the resources I need? What type of resources do I need? Where do I get the research for it? Where do I find the attorneys to help me? Where do I find the experts, the specialists, evaluation analysts, as the case may be, from beginning to end? And that keeps my overhead very low through the entire process. So I don't engage all of the help that I need or all of the staff that I may envision at the onset, but bring them in as and when needed, on an hourly or a set fee basis, as would be predetermined, and we usually apply those standards from the case-to-case basis. And at every point, as soon as anybody else is brought in, it is only with the written consent of the client, and that is also addressed in the engagement letter. So the important reason that I brought up the project management issue is that I believe this spring, it was either the ABA or one of the legal practice journals, had written that more and more large firms are employing project managers in-house to assist them with managing the law firm as a whole. The law firm itself is a business. Whether you're a solo practitioner, a small firm, or a large firm, it has to function like an organization. But we tend to look at ourselves as individuals with our own clients, and the concept of taking our clients where we go is very popular, which doesn't necessarily work with the changing dynamic of the world today and with the nature of the businesses and the clients, because they expect legal services from an attorney who can basically be their one-stop shop. So, and we cannot do that legally or ethically. So collaborations, networking, and being able to have access to and having planning for budgeting, advertising, marketing, all of those resources and tools while maintaining your brand in that niche practice, as your name has to be associated with the practice area that you want yourself to be associated with. But your firm can be one that can provide additional legal services or an expanded practice without stating or without creating the implication that you're the one who does all of the work. So that requires some expertise. And the next slide does go into some technical terms on project management, where a project manager will create a statement of work. It's essentially a management principle, create a framework, how to add, how to budget. you essentially, when you reduce overhead and have some money left over, you can now use it for branding and marketing and all those things that attorneys generally don't like to think about, but that's what generates clients. And for that purpose, I've included a short handout, which you can read at your own convenience, on how project managers actually assist law firms and attorneys specifically, and the importance of project managers to understand law firms as a separate type of business model to be able to assist appropriately, in addition to understanding that we have very, very stringent security and confidentiality issues that also have to be addressed in any collaborations that they may come up with to reduce our overhead. And this brings us to the final aspect of the multi-jurisdictional practice, which is how do you advertise? Every bar association has stringent rules on marketing and advertising, and it is important that you collaborate all of them. If you go to my website, you would see that there is the disclaimer required by the New York law, the New York bar. Then there's a rather lengthy disclaimer that if you combine all the jurisdictions that I practice in, should satisfy every jurisdiction's rules. And then the content of the website itself is very much in line with the jurisdictions that I practice in. It doesn't use words such as expertise, specialization. New Jersey only allows trial lawyers to be certified, so it doesn't use any certifications. I have an LLM in tax, but I cannot state that that makes me a tax expert, right? That's too loaded a term to use, even though I do have significantly greater knowledge in tax law than, say, I would have in family law. But I have to be careful in how I present it, so it is easier to present it with specifics on my past experience, and then let the prospective client determine what that means, make references to other jurisdictions I've practiced in or my affiliation with other jurisdictions so that the client would end up getting the hit on their websites or their searches to my name and my firm. Social media is a huge issue. It is one of the best ways to advertise for a solo and small practitioner. It is very cost effective. However, even in the ABA Formal Opinion 466 in 2014 was one of the latest opinions. It doesn't have to do specifically with social media advertising by attorneys, but it has to do with the fact that when attorneys looked up for jurors' information on LinkedIn, it constituted unduly influencing the juror. If the standards are that stringent and the area of what constitutes solicitation and how social media can be used is gray, then it's very tricky to use social media for advertising purposes. What I have found is that it's generally okay to use social media as a point of information, reference articles that may be of interest in your practice area, comment on recent case law and your analysis of them, or something that would interest the general public. And my favorite word to use is generally, which very specifically indicates that this is not client advising and it's not specific to any client. And that sort of lets your knowledge be spread among the general public without creating an attorney-client relationship in most instances. But it is something that we have to constantly keep an eye on for recent changes in the law. And the idea of marketing in multiple jurisdictions is that we have to keep abreast on the law as it relates to social media advertising in multiple jurisdictions, which may be completely contradictory. And my approach is to take the most conservative approach. Whichever jurisdiction has the most stringent standards, if you follow them, generally you should be okay with your practice. And the last poll here, to again get an idea of what type of issues the audience may be facing. Are you a transactional practitioner or a litigator? I can answer litigator, a transactional attorney, both about equally, both primarily a litigator, or both primarily a transactional attorney.
Okay, excellent. So if everyone can please wrap up voting. This is our last poll for the webinar today. And Okay, looks like the majority have voted. I'm going to go ahead and close the polls. And our immediate results. Okay, so are you a transactional practitioner or a litigator? 13% said litigator, 46%, so that's our majority, say transactional attorney. 7% said both of that equally. 10% primarily a litigator, and 24% said both primarily a transactional attorney. So there they go.
Okay, that's very interesting. And as I said, multi-jurisdiction practice is very much possible in a litigation environment, but it may be easier to be a litigator in jurisdictions that are at least in close proximity to each other rather than representing clients in, say, New York and California. So, and so finally, this was probably the most interesting topic to the attorneys who have one single practice area or a few and are looking to enter into multi-jurisdiction practice, is to increase, how do you increase your rate of return in a virtual practice, especially with the myriad number of ethical rules and prohibitions I've just mentioned that could avert you from practicing in multiple jurisdictions or expanding on your practice. The networking and creating good professional relationships has been the key to the success of my practice that is globally based. I have received almost all of my clients through referrals from other attorneys, legal professionals, and experts in areas not, and I can use the term experts because they're not attorneys, such as evaluation or inspections and things of that nature. And creating collaborations, such as doing the independent consulting or independent contractor, also offering consulting to law firms on a fee basis. I usually offer a reduced hourly rate to fellow attorneys when they need to consult on a tax issue, on general matters for multiple clients. So I'm not hired by the client, but I'm retained by the law firm itself. Using resources online and tapping into the hourly paralegal, the flat rate legal assistant, using interns, but you have to subject them all to confidentiality agreements, make sure that they have experience with the legal profession and you're not risking your client's information or the services you provide by engaging temporary staff. So I do engage temporary staff, but I engage them repeatedly, so they are well known to me. And it keeps my overhead low, and they are happy to be paid on a project basis because when the project arises, they're assured of their fee. And you develop law practice management goals based on the service you can provide, how much you enjoy the work you're going to do, how creative it is, instead of focusing on the amount of time you'll expend on it, where it is located, or the actual expense of running a practice that is this broad-based, because in the short term it may be more expensive because you need to have the right tools to get the correct things in place. Electronic signature software, secure software, document management software, but in the long term significantly reduces overhead and increases your client base. And technology, virtual office, good collaborations, a good network, staying abreast on the law can make having a multi-jurisdictional practice possible for anyone, especially if you can waive in and not have to take a bar exam. But with that, I just wanted to thank you for your time, and any of the references that I made in these slides that are not provided, I can provide them to you if you email me, including any ethics opinions, and I'd be happy to answer any questions offline as well. And now I'll hand it over to Stephanie for moderation of any questions that have come in. Thank you.
Okay, great. Thank you so much, Priya. That was some great insight. We do have some really wonderful questions that came in. But first, for those of you who have to leave us now, please take note of 3 things. MyCase offers a 30-day free trial, and since you attended this webinar today, you get a bonus discount. So please note the promo code 10GLO15. For when you activate your account, you can also tell this to your software specialist. And secondly, When you close your webinar, a survey will pop up. The starred questions are required for those applying for CLE credit in the states I mentioned before: New York, New Jersey, Illinois, Arizona, Texas, Wyoming, and Louisiana. You will be receiving your CLE certificate by email from Esquire CLE within a few days after the webinar today. The other survey questions are for everyone, and to encourage you to fill those questions out, we will select one lucky survey responder to receive a $50 Amazon gift card. You'll receive an email tomorrow with a link to the blog where you will find these slides, the webinar recording, and the Amazon gift card winner. Okay, so I have a bunch of questions coming in right now, but let me tackle a few that came in during the webinar. Okay, and so Priya, this is a little bit of a longer question, so I'll read it slowly for you. Priya, I handle business matters in the state of Alabama. I really want to move into general counsel and business strategy type of work. I want to work with business clients in multiple jurisdictions, but I do not handle universal areas such as tax. How can I really expand the practice and not bridge into UPL?
I think this goes back to the idea of networking and collaborations. Then the best way to do it is, since you are experienced in business law and you do want to perform general counsel functions, you can do the same thing that actual in-house counsel do, which is that they have focus areas, but they go to outside counsel or attorneys who actually have a focus or experience in a particular area, such as tax, to either retain for the company. In your case, you would either bring them in as independent contractors that the law firm retains on an hourly or a flat fee basis on those tax issues, for example, or you can, with the approval of the client on a particular matter, tell them that even though you don't handle those other related areas, you have the resources and the network and the ability to consult with those attorneys, and you can bring them in as part of your firm on just that matter. And that's how you can expand without running into EPL issues. Of course, you have to check your Alabama rules specifically. I'm not familiar with the Alabama ethics rules, but that has been a model that generally works in the jurisdictions that I practice in.
Okay, great. Another bit longer question as well, so I'll read this one slowly as well. For purposes of advancing a global practice, what advantage or advantages, if any, do you see in an attorney admitted in one or more states in the United States becoming dual qualified in another country where he or she wants to develop business? And then the question continues, to the extent there is an advantage or advantages, could you comment on the merits of either becoming a full member of the bar of that foreign country as opposed to a status such as a registered foreign attorney in that country? I don't know if that means.
You're talking about being a foreign barred attorney, and I actually do collaborate with foreign barred attorneys. It depends on the type, the area of the law and the jurisdiction that you are specifically referring to in terms of whether it is worthwhile to be admitted to practice in another country altogether. I have attorneys who are, let's say, international estate planners who represent clients located abroad with property interests in the U.S. who are admitted to a jurisdiction in the United States and also, let's say, a European country. Almost 100% of their practice is enhanced and more lucrative because they can actively practice in both jurisdictions. Many of the jurisdictions, especially the Asian countries, do not allow for American attorneys to have resident attorneys to have an office abroad without being physically there or collaborating with attorneys who are already barred and residing in those countries. So I have found it more lucrative to just, again, develop those independent contractor relationships and collaborate or co-counsel with foreign barred attorneys on the foreign issues. So it depends on what percentage of your representation is actually an international issue as opposed to a domestic issue. If you have an international or global client coming in with predominantly domestic issues, you don't need the foreign barring, and it may be a waste of your resources and your time to have multiple jurisdictions when you could just expand your network and share some of the profits that you make with another attorney to offer those enhanced services to the client.
Okay, great. No, that's great. The next question is very short compared to the others. What type of payment methods do you use to process your payments, Priya?
That's an easy one. I accept all forms of payments, from the traditional check to I use MyCase, not surprisingly, and my clients pay by credit, debit. Now they can do eCheck, which is great. I've also had funds wired to my checking account and trust account checking account for completed matters directly. And there have been no issues, especially since I use the memo lines. So especially the credit and debit payments and the electronic payments have ensured that my clients pay on time and completely, with much fewer issues than back in the day when I could only accept paper checks.
Okay, great. And thanks for the shout out for that one, Priya. Okay, this is a bit of a personal one. I'll throw it out there. If you don't want to answer it, you don't have to. I'll just make that determination now. This person, it looks like they're looking to branch out on their own. So they're asking how long, months or years it takes for you to replace or exceed your compensation when you left the IRS. And do you sleep at all, or do you work 24/7?
Okay, I'll actually share even more personal information, so that should help. I essentially exceeded my IRS compensation working part-time with a newborn and having relocated to a new jurisdiction. So, and I was at the top of my ladder at the IRS. So it doesn't take long, but I have several years of experience as a tax attorney, so I already had a client base. So that's a big difference, because I had my own practice, then jumped into the IRS, and then came back into private practice. So it's a little bit different from somebody who would be starting out. But if you're expanding, your return should be very high, because you'd be expanding on your already established reputation and brand recognition, but just increasing your client base itself.
Okay, great. And I've heard you've been asked by other bar associations to do this exact webinar, because like Washington, D.C., right? They'll be doing this webinar again because you have...
I've been approached on the multi-jurisdictional issues. I think that's a hot topic now, because more and more attorneys might be looking to branch out. So I'm happy to share any information that I have, and if it needs to be more specific, I can do that as well. This was more of a broad brushstroke for people primarily looking to enter into that area. So.
Okay, great. And then another good way for people to contact you, would that be by email? Would that be the best way, Priya, for people to contact you?
Email is ideal. Phone is fine as well, but email, I do tend to respond much more quickly. As you can guess, with the multiple jurisdictions, I do travel a lot, so it's I'm much quicker with email.
Okay, great. Okay, moving on to next question. Who do you use for your contracted legal work?
Say that again?
And I don't know if that's too personal either, but who do you use for your contracted legal work?
It's not a specific company. I have multiple attorneys and people in my network, including paralegals, that I use on an hourly or contractual basis, and I will admit that it has been a trial and error process in the past. So we have had changing relationships and changing independent contractor agreement terms as I learned lessons from prior mistakes. So.
Okay, great. And then I just had a funny question come in. How are we not hearing your baby and your dogs? Someone was impressed that you have dogs in the house and a baby. So.
I'm very good at silencing everyone. I'm just joking. No, it's you know, I have my own home office, so I have a very secure area that I conduct all my work without interruptions. So.
Okay. Okay. So it seems like you're a very intriguing personality, Priya. So people had some personal questions. If you weren't an attorney, what would you be doing?
I'd probably be an artist or something very, very creative and the opposite.
Okay, great. All right, thank you. And thank you to everyone who submitted your questions today. It is 12 o'clock, so we are going to wrap on that. But if you have any questions for Priya, please reach out to her at her email address provided on that Contact Us page in front of you. And for those that did join us for CLE, you will be receiving a certificate by email from Esquire CLE as long as you attend it for the full amount and you fill out the survey that pops up. And again, the survey with the starred questions are the ones that are required for those that are applying for CLE. So Priya, thank you again for being with us today, and thank you to all those that attended. And we'll see you all next month.
Thank you, Stephanie.
Okay, thanks Priya. Bye-bye.